Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Welcome to Debt Collecting, how to locate bank accounts and other assets to enforce judgments. We will be talking about several techniques to actually locate your bank accounts, and then a few of the processes to use to lead that to the recovery of the actual assets for judgment enforcement. I want to start here with the very first slide, where we will be setting forth several of the examples across the top here. We're going to start on the upper left-hand side with UCC's filings. It's Uniform Commercial Code filings, and these UCC filings are used to record a security interest in any asset that does not have a title to it, such as heavy equipment, so forth. We all know that if we buy, for instance, a washer and dryer at a department store, that if we do not pay for that, that the seller has a secured interest in it and they can come repossess it. Of course, there's no title like there is on a plane or a car or a boat or something. So how do they perfect that interest? They do it by filing a UCC, Uniform Commercial Code filing. In most states now, I believe those are filed with the clerk and recorder's office. In some places, they're filed with the Secretary of State. So search for your UCC filings, and that will tell you who the lender is on that asset. The lender is quite often a financial institution. More often than not, on the personal property, it may be a bank that the selling organization has an affiliation with. So you can do a couple of things with that. One is everybody assumes, and let's take, for instance, say it's a Caterpillar, heavy equipment, that if it is secured, that you can't take it and liquidate that asset. That is incorrect. The secured party is only interested in getting their money. So the example I like to use is on earth-moving equipment. Say it was purchased for, let's make it easy and give a round figure of $150,000 3 years ago with a $50,000 down payment, and say over the years they've paid $25,000 in payments before you find it and decide that you may need to liquidate that asset. Now, if the construction business is going well over the last 3 years, it may be that the value of that used equipment is now up to, say, let's just routinely say it's $125,000, the original price, because the new ones would now be selling for $175,000. So if we take that figure, you take the equipment, tell the seller that you're going to, or the lender, that you're going to pay them off. You liquidate it. Let's say you get $125,000 for it. There's now $75,000 owed on it. So you pay that off. You make $50,000 that everybody else has overlooked because they thought it was a secured piece of equipment they couldn't take, when in fact they can. The other benefit, if this is not a bank that is doing it, you can go to whomever the lender is and see where the funds are coming from to make the monthly payments or the quarterly payments. With that subpoena, you will get back the payment instruments, which are usually company checks. So you now know a bank that your lender is doing business with, and we'll talk in a few minutes about what you can do with that bank account information. So you have found banks using the UCC filing. So let's now move over to one of my favorite sources, and that is the defense attorney for your debtor. As soon as the judgment is being collected or enforced, the first thing the judgment debtor is going to do is to hire an attorney to defend himself with and to help minimize his losses or the payments he has to make. So the attorney, of course, is not going to work for him unless he has a nice retainer. So the example that I use is a case that we actually used where the attorney took a $5,000 retainer. Well, the first thing I did was wait till the next Monday after we knew that the attorney had been engaged. That gave him time to get the check delivered to him. So mid-morning on Monday, I served him with a garnishment and a subpoena for a copy of the check that he had received from his client. So we saw what bank it was coming from and what account it was coming out of. But we also got the $5,000 because the attorney's retainer still belongs to the client until the attorney has earned it. And if it's the same morning that the attorney deposited the money or it cleared the bank, he hasn't debited against it, and if he has, it's a very nominal amount. So in this particular case, I visited this attorney for 3 weeks on Monday morning, and every time I got $5,000 from him. The fourth time I went, he got wise and decided to take his retainer from somebody other than the judgment debtor. So he took it from a relative or a friend or from somebody else. So it wasn't the client's money, and I couldn't get it the fourth time. But we got $15,000, which was a nice little war chest for my client to use to proceed with his enforcement procedures. So that was a lot of fun and a good source, and they always have money. The next thing we'd like to look at are the litigation files. So go to the courts, see what litigation your debtor may have been involved in the past, and it could be financial institutions, it could be whatever, but there were always checks floating back and forth during that litigation. So you can read the files, see who was receiving money from the judgment debtor, and those can give you some excellent leads. The next place we like to look, of course, you have a debt. It's a legitimate debt, so you have the right to get a credit report. The credit report is going to reflect every financial institution that the client does or has credit with over the last 2 or 3 years. So you can then go to each of those with a subpoena, and always remember when you are going to a financial institution, you not only want to garnish the money that they have now, but you also want to subpoena at least 24 months of the credits and debits. And then you will see all of their sources of income. So you can go to those sources, intercept the funds before they hit your target's account. And then it's the corpus of those sources. For instance, if they have oil and gas income, you're not so interested in the monthly checks that they're getting from the oil and gas companies, but you are particularly interested in the source of the money, which would be their investment with the royalty company or the producers of the oil and gas holdings. So you want to then go to them and put a lien against those assets and confiscate them with a turnover order or whatever is appropriate in your state. So not only do you get the current cash flow, but you also get the corpus of that investment. Again, if they have income from rental properties, say it's commercial property or residential properties that they're leasing or renting every month, you're not so interested in the monthly checks as you are going and taking that rental property that could have substantial amount of equity in it. You can liquidate that asset, and whatever the liquidated equity is goes to your client. So another good source of income from sources that others are often overlooking. They want to garnish the income, but not necessarily the corpus of the investment behind it. So Department of Motor Vehicle liens, same thing. You go to the Department of Motor Vehicles, that's public record, pull the title on any vehicle that they have registered to them, and you may find, in addition to automobiles and trucks and so forth, you may find any vehicle that runs on the road. So if they have farm equipment that has to be driven up and down the road, they have to have license plates for it, and they have to have the title registered with the Department of Motor Vehicles. So all of those things you can find, and from that you find out where they're being financed. You go to them, you do a garnishment for anything that they may have in any accounts there, and you also take that asset and pay it off and take the equity out of it. With any of these lenders, also be sure to subpoena at the time you are garnishing and subpoenaing them. Be sure your subpoena asks for a copy of the loan application and all support documents. The support documents oftentimes include tax returns and financial statements, both personal and business financial statements. On that, you get a wealth of information. So you find on their financial statements every asset that they have that they're claiming to show their credit worthiness at the time they've made that loan. Now, either they still have those assets or they've disposed of them, but if they disposed of them, that leaves a trail. And where did the money go that they got when they disposed of those assets? And where is that money now? Was it reinvested? Did it go into the stock market? If it did, you want to trace it there, recover the money from those sources. So getting the financial statements and the tax returns are very, very valuable. Next place we want to look at is the loan application for loans and mortgages. So if your target is buying a home, they are financing that home in all probability, and the lender will have both loan applications and support documents. But if you're making monthly payments on your home, they consist of four things. That's principal, interest, taxes, and insurance. So the principal payment goes to the lender. The interest goes to the lender. They are escrowing for taxes. And the reason they're escrowing for taxes is because the lender does not want to lose their collateral at a tax sale when they haven't paid the taxes on it. So they're escrowing for it and paying the taxes. Likewise, they are escrowing for the last one, and that's for the mortgage payment. So does it not make sense to all of us? We know this, we just have to think about it, that if they are escrowing for insurance, the lender must know the name of the insurance company, they must know the address of the insurance company, and they must have the policy number for which they're making the monthly or quarterly insurance payments. So if the lender has that information, they get the next subpoena, and we say, provide us with the name, address, and policy number of the insurance company that you're making your monthly or quarterly escrow payments to. They provide that to us, and then that next subpoena goes to the insurance company. And we say, provide us with a copy of the insurance policy along with all addendums, amendments, and schedules thereto. And that, my friends, is where you're going to find a list that is not available anywhere else in public record that gives you the most valuable personal property that they own. I don't know how many of you out there may be a student of Sun Wu, who wrote The Art of War, but I have about a dozen different translations of The Art of War, and I am a very good student of the art of war, because there's so many good things that are said in the art of war that applies to judgment enforcement. The one that I am fondest of is take from a man that which he cherishes, and he will follow your ways. So you find what's near and dear to their heart and take it with a court order, liquidate it, and oftentimes that is all it takes, is just getting that court order and starting the process of confiscating that asset. And oftentimes I have more than a dozen cases in the last 2 years where we have settled the case for 100% of the amount of the judgment and didn't have to actually execute on the writ with the sheriff's department, because we're about to confiscate something near and dear to their heart. So if you get that policy, they're going to have scheduled their own all of the valuable jewelry, and I guarantee you nobody is paying a premium on a Rolex watch that they do not own. So you're going to get all of their diamonds, their jewelry, their watches, and so forth scheduled on the policy. You're going to get their valuable artwork scheduled. You're going to get their furs, their antiques, all of their collectibles that are usually very valuable, Persian rugs, whatever the personal property is. And keep in mind, folks, this personal property has no title to it, so it is not in public record anywhere. The only place I know to get that and get the value of it is from the insurance company, where they have added it as additional scheduled property beyond what is generally covered in the policy for furniture and day-to-day household appliances and clothing and so forth. So when you start taking those valuable personal assets from them, you have their undivided attention, and that often gets a settlement. Let me give you an ideal example. We were doing our comprehensive report for our preliminary investigation on a debtor. I found that, again, from public record, that he was every year getting a big game hunting license in Alaska. And he had done this for 8 years in a row. You don't get big game hunting license, in my opinion, in my experience, and I've been doing this for a little over 50 years, you don't get big game hunting license year after year unless you're a trophy hunter. And trophy hunter has to do with the ego and these things. I like to look at the psychographics of my debtor as much as I do the demographics. What makes them tick? Well, a person that is going to be having trophy hunting is going to have a good bit of trophies either in his office or his home or both. In this case, this guy had all of his in his home, in his family room. So we get our writ of execution. I have prearranged with my debtor, of course, to go with the sheriff's department, and we help them by, and they're always welcome to have the help. We provide a locksmith, so if the premise is secured, even though the sheriff or the marshal, if it's a federal case, has the right to break and enter, you don't ever want to do that, because one, you don't want to do damage to the office or the home. Secondly, you want to be sure that you can secure the premise if you leave, should there be nobody there. So locksmith is a logical thing. And when we're recovering hundreds of thousands to millions of dollars, a few $100 for a locksmith or whatever the fee is nominal beside the potential that you have on the upside. So we take a locksmith. I take one of my staff people that's a photographer, and we have a movie camera, and we take a camera of the recording of the inside of the premise. So if they later say we damaged the premise, we kicked a hole in the wall or whatever, we can show the condition of the premise when we get there. And we do it again before we leave, so we show what the condition of the premise is upon departure. So that gives us a good record. We inventory everything that we take out to the moving van, photograph it on the way out, and keep that inventory. So we start our writ of execution with the sheriff's department. The sheriff tells the debtor, okay, Mr. Jones, you may stay during the execution of this writ. However, you must sit over here in the corner of the family room. And if you get up one time and interfere with the execution of this court order, I will put you in jail for interfering with the court order. Do you understand me? Oh, yes, sir. I won't be causing any problems, I assure you. So he sits himself down. I tell the movers, okay, guys, here's the first thing we want to do. We've got a standing polar bear over here in the corner of the family room. I want you to wrap this guy in the bubble wrap, everything you've got to secure him, put him in this big crate, be sure he is well secured, and then move him out to the moving van, secure him in there. And when you get back, we'll want to be taking the moose and the caribou and the mountain lion. Be sure to prepare them the same way so that there's no damage to any of these valuable trophies. Well, the debtor just couldn't stand it anymore. So he jumped up and he said, Mr. Dickerson, could I please speak to you? I said, of course. What do you have in mind? What do you need to discuss? He said, well, what can I do to get you off of my posterior? And I said, well, look, I'm a very reasonable man. All I want to do is get what the court has ordered that belongs to my client. But you need to understand, I wish you no ill will. In fact, I wish you every success in the world because you're now our business partner, and every dollar you make the rest of your life, we're taking part of it for our client. So he says, well, what can we do to make some of this go away? He said, I'm willing to, I recognize I owe the thing, but I just can't come up with all of it. Well, what'd you have in mind? He said, well, could we do something with the principal and interest? I said, I don't know. My client's pretty tough and they're pretty demanding, but let me go outside and make a phone call. I'll call my client and see what they have to say, and I'll get back with you. So I went out to the front yard, sat down in his swing, watched the squirrels and the rabbits for a little while, checked in with my office to see if I had any calls. And I had prearranged with the client that we could forgive all of the interest and insurance interest and cost if we had to, as long as we could get close to 100% of the equity. We were willing to go down to 80% if we had to stop the legal fees and get cash in the bank and move forward. So I had this negotiating authority already from my client. So I went back in and I said, well, my client's pretty upset about this thing. I tell you what, if you can do something with the part of the interest or the cost on this thing, we may be able to come up with an agreement. Well, to make a long story short, we agreed to reduce all of the cost and a part of the interest. And the agreement was that he would pay us 100% of the principal amount of the judgment within 10 days in cash, or we would be back with the sheriff's department and we would take all of his assets. And within 10 days, we had 100% of our money. So take from a man that which he cherishes, or threaten to take it from him and let him know you're serious, and he will see your ways. And that's exactly what happened, and that's what we like to do with these things. So anyhow, you're beginning to see how some of this stuff can work. The last one over here are private vendors. There's always ways to legally, in compliance with Graham-Leach-Bliley, which is the law that says you cannot pretext banks and you have to obtain any banking information in complete compliance with Graham-Leach-Bliley. And the penalty for violating Graham-Leach-Bliley is up to $10,000 or 10 years in jail at the discretion of the court for the investigator or the research firm that places the order, for the company that provides the order if it's not in compliance, for the client that uses the information, and for the attorney that puts that information to use. So I tell people, look, I've got some pretty foxy clients, but I don't want to spend 10 years in a jail cell with any of them. So we're going to do it legally or we're not going to do it at all. But as you can see, there are many ways besides going to private vendors that you can get, use all of these sources across here to find bank accounts. A couple of others right quick that we'll go across is treasury management information. We have a subpoena that we issue to the debtors that ask for everything that they possibly have not to the debtor, but to their financial institution, that gives the bank absolutely no wiggle room to say, well, you didn't ask for that, because we're asking for all of it. And with that information, we know where all of their bank information is. For instance, I had one guy that had an account in a bank in Salt Lake City. However, he officed and lived in the state of Oregon. And I like to garnish the banks on like the 17th or 18th of the month, or the 3rd to the 5th of the month. So any credits have had time to be credited to their accounts, but anything that's being debited on the 1st and 15th may not have cleared yet. So you have the highest probability of getting the most for a garnishment in that first few days after the 1st and the 15th. So that's usually when we do our garnishments. So we would garnish knowing that this guy was putting all of his money into this particular account. And every week after the garnishment, or every month on the 1st and 15th or shortly thereafter, we would garnish and come back with zero balance, zero balance, zero balance. And I got to scratching my head and said, there's something wrong with this program. So we did some research into the bank and found that it was owned by a bank holding company. And that company owns banks all over the country, plus some international banks. And what they were doing is this guy had a sweep arrangement whereby every afternoon at closing time, they would sweep his account. Every dollar that he had in each of his accounts, or in the particular account that we knew that he had the money in for his operating, they would sweep all the money out of that, send it to the offshore bank account. And then anytime there were any debits against his account, they would sweep the offshore bank just for enough to cover the current debits, pay those debits, and he still had a zero balance at the end of business every day. So we expanded our garnishment and went to the head of the bank and said, in any and all banks in which this person has accounts, we got our money. But it had to go beyond the obvious. So the Treasury management subpoenas are very valuable. And any of you that need a copy of that, please contact me, and I'll be happy to furnish you one free of charge. The FBAR reports, this is the financial asset reporting reports that must be made on April the 15th of every year, and they go to the Financial Crimes Division of the Treasury Department. And this is separate from income tax. It has to go out every year, and for any account that has accounts that have an aggregate of $10,000 or more on any day during the year. And failure to report this, again, has substantial penalties up to, I think the last time I saw it was $124,000 or 10% of the amount held in those banks at any time during the year, or some combination thereof. So this is pretty serious stuff. You find that the CPA usually has a copy of this, the bookkeeper and accountant usually has a copy of it, and the debtor should have a copy of it. If they don't have, they're in serious trouble, and they oftentimes would prefer that we not report this to the federal authorities, and oftentimes think it would be much less expensive for them to pay their judgment. I have no ill will. Like I said, all we want is 100% of what our clients have coming to us. And the last place over here is Intermediary Bank Discovery. And this is a process that I would say top side of 95% of the professionals in the United States do not even know about. It is the most powerful tool that I have ever seen, and it allows you to go. There are only about 5 or 6 intermediary banks in the United States that all wire transfers clear through, whether they're going or coming, inbound or outbound wire transfers, all clear through these 5 or 6 banks, all of which are in New York City. And we have our attorneys draft a very broad subpoena for any and all wire transfers in the name of our debtor, and we use any combination of that name. So like for me, my name is Joe Dickerson. My middle name is Henry, so we do Joe Henry Dickerson, Joe H. Dickerson, J. H. Dickerson, J. Henry Dickerson, Henry Dickerson, any combination of those names, and business names, any combination. If it's incorporated, you get Inc., INC, incorporated, any combination of those things. You will get a good many false positives because the bank will give you any and everything coming or going from any bank anywhere in the world, because most all of the foreign wire transfers clear in US dollars and they clear through these banks. So if a check is going from Saudi Arabia to London, it will go through one of the intermediary banks in New York and then go to London. And let's say your debtor is moving $10 million, for example. Those go through the New York bank, it goes to London, you find that it went to London, you get the name of the bank, the account number, and the name of the account that the money went into. From London, let's say it goes then to 10 different banks in 10 different countries in 10 different names, business names or individuals' names. You then can trace it to each of those 10 banks and say the money's still there, which we have found good portions of the money there, or trace it till you get it all. You can get international freezing orders to freeze those funds in these international or in any bank that it has gone to, and then get the money released through the federal and international courts back to your client. It happens all the time. You just got to be able to trace the money, and this is the most powerful tool I have ever seen. And the federal courts have held that information does not belong to the sender of the wire transfers, nor does it belong to the receiver of the wire transfers. It only belongs to the international bank, the intermediary bank that it's going clearing through in New York, and that bank has no dog in the fight. They're merely a conduit, so when they get a subpoena, they have to reply to it. And it is not inexpensive, but if you're chasing hundreds of thousands to millions or billions of dollars, it is well worth the investment, and it is very chilling to the debtor. So that is a fabulous tool. And don't forget about the intermediary bank sources. So now we will go to the next slide, and it shows you the places from the bank that the money may be moving to, and you can go to each of these. And those are safe deposit boxes where you can get break orders. You go in the safe deposit box with the sheriff or the local police department, or whomever the break order is sent to. Again, we have a locksmith come with us. They drill the lock. You get into the box and you find wills, you find trust, you find jewelry, you find all kinds of valuable personal property, including cash, bonds, and other securities. So finding that safe deposit box, and here's something you want to ask for when you're subpoenaing the bank, is all safe deposit box information. And by the way, I failed to mention this a while ago, but when you're subpoenaing the bank on these wire transfers, used to you had to have a written wire transfer order. So that's back when they would fax the wire transfer instructions and sign them and fax it to the bank with written instructions of where to wire the money to. And nowadays you can do this electronically and verbally. So when you call the bank still has to keep a record for 7 years of all of those instructions, and they have in the files of the bank who is authorized to give verbal instructions for a wire transfer. So we just subpoena the bank for a electronic recording of the voice instructions, and then we play that for the judge. You talk about a hush coming over the courtroom. When you are playing the debtor's voice instructions to his bank to move $500,000 from his bank account in the U.S. To his offshore bank or to various offshore banks, and giving the account number and the routing number for that money to go into. I have never, ever had a judge refuse to give the debtor an order, and the order says you will immediately repatriate those funds to the jurisdiction of this court, who shall then order those funds payable to the judgment creditor. Failure to do so will be contempt of court, and you will be put in jail for contempt of court. You've got 10 days or whatever the number is. So you can't go to jail in the United States for your debt, but you certainly can go to jail in the United States for failing to obey a court order. So that gets pretty serious pretty quick. So be sure and ask for those voice recordings. Okay, back to where we were. We were talking earlier about you want to ask for all credits and all debits for the past 24 months to get those sources of income and where the money's going. So money coming in, you want to get the corpus of the source of the funds. Money going out, are they moving it to a brokerage firm where they have investments? Are they moving to shell corporations or to offshore entities? So we want all money coming in, all money going out, and records and documentation of same. We talked earlier about the loan applications and the mortgage company and the importance of having the mortgage company so we can subpoena all of the information from the mortgage company for the insurance records and so forth. And account signature cards, because you want to know everybody that is authorized to sign on that account, because the account may be in one or two people's name, but you may have, like for instance, my adult daughter in another state is, actually two of my daughters are authorized to sign on our accounts if the wife and I can't sign, but there's no condition on it. So if they needed to sign a check, we were hospitalized or we passed away, they can do it. There's nothing to keep them from signing a check that we ask them to pay a bill or do anything else with. There may be situations where with a questionable individual, they may be having all the checks signed by their adult children. And we've also found accounts where money was coming, account we're working right now, where money came from 12 different accounts in Greece. Each account was for a condo that was owned by our client in Greece that we did not know about until we found these. Those 12 banks, the wife was taking money and transferring it to the daughter in amounts of less than $50,000 every month until they had accumulated $500,000, and then the mother signed on that account. She bought for the daughter a $500,000 annuity, and then waited about 3 months and had the daughter cash in the annuity. Some people think that may have been money laundering. We'll wait for the courts to tell us whether or not it was, but we did learn about the condos in Greece, and they all now have been tied up by the courts over there, as have the 12 bank accounts. And the people that were signing those, who are all relatives, in addition to the mother, are all now under investigation for their participation in, again, what may well be money laundering. So you can bring a lot of pressure with this kind of information. I hope what we have covered today is helpful to you. If we can be of assistance to any of you, feel free to give us a call at Financial Forensic Services. We're glad to answer your questions or assist in any way we can. You can get our contact information from OffshoreAlert. It has been a genuine pleasure to be with you folks today. Thank you very much for your attention, and look forward to hearing from you if there's something we do for you. Good day to you all.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.